Welcome to the latest in our risk series. I'm Paul Marshall and I'm joined today by Ian Rutherford and Ross Campbell. Ian's a partner and Ross is a senior associate in our commercial disputes team. Now, we're all familiar with what it means to limit your losses, and we know when we are in a damage limitation mode. Today, we're going to look at limiting and excluding liability in contracts. Now, we believe that this is an important way to manage commercial risks in a business. So Ian and Ross are going to navigate us through this tricky but essential area of contract law. So welcome both. And Ian, can I turn to you to start? What do we mean when we talk about limiting or excluding liability through contract?
Thanks, Paul. At a very, very basic level, we're talking about limiting liability. It's really about certainty. It's about making clear that if there is a breach, what the extent of that liability is. And commonly, and we can talk about some of the different ways that is done, commonly that is done by actually putting a number, saying that no matter what happens here in this contract, if we breach it, this is the extent of our exposure. Obviously, excluding liability is different in that you are saying if X or Y happens, before the performance of this contract, we will not be liable for that. So there will be no exposure to us. And these are things that are agreed or negotiated between the parties to give that degree of certainty that I mentioned.
Great. And why is that? So you talk about certainty, but why is it important to limit or exclude liability?
I think it's business risk, really. I think, and it works for both sides. I mean, you often think about limitation of liability working for the party who has limited their liability, and you can see the benefit of that if you have a number of contracts with a number of different parties and something goes wrong in one of those contracts. It's helpful to know that even in the worst case scenario, you're only going to be liable up to a particular amount of money. But equally, if you're on the other side of that contract and you're the party that has suffered the loss, it is also helpful to know that the maximum you're going to be able to recover is X amount. So it's about achieving that kind of business certainty. And it's also, I would say, an important part of just that negotiation process, the stage where the contract is being agreed and accepting what the kind of acceptable allocations of risk are between the parties. But I mean, there's a fundamental reason that it is important to limit liability in contract. And I'm not going to bore everybody with too many war stories, but I've spent the best part of the last 4 years managing a dispute for a party that supplied pipes into a major oil and gas structure. They were simply acting as a middle entity. And they bought pipes from one entity, then sold them on to another. So the amount of money they made on the transaction was in the low tens of thousands. They installed them into this oil and gas structure. The pipes failed, and their liability for that failure ran to millions and millions of dollars. And they had not limited their liability. The party that they had bought the pipes from had limited their liability. So on the face of it, they were facing a significant claim. Happily, well, one way or another, there was a fraud element to the supply of the pipe, so there was a way around it, and we can talk about that in a bit more detail. But that's the issue. If there is not a limitation of liability, even if the amount of money that you are making on a contract is small, your potential exposure could be great because you don't necessarily know what use the products you're supplying or what use the services you're providing are actually going to be put to. So that's hopefully not too much of a war story, but that's a bit of a lessons learned.
No, that's great, and I like a chilling example at the start for everyone to understand why this is important. So Ross, Ian's explained really clearly there why it's so important to have this in your mind when you're negotiating your contracts. And that sounds great, but what are the fundamentals you have to get right so that when you've got your fantastic clause to limit your liability, it then stands up to scrutiny, it does the job you need it to do?
Well, I think what you would ideally want is a clearly worded contract or a clearly worded clause, which is as free from ambiguity as possible. If you're dealing with a negotiated commercial contract and clear and unambiguous language has been used, generally the courts will give effect to what parties have agreed and will be quite slow to interfere. Whereas if the clause is not sufficiently clear and a dispute arises as to its meaning, the parties may then be in the hands of the court in terms of how the clause is to be interpreted. And once you're in that territory, the courts will kind of generally approach interpretation in a sort of set manner, not to get into the sort of detailed case law. There's a sort of relatively settled test from the sort of case Wood versus Capita Insurance in 2017, which effectively sets out that the court will look at the objective meaning of the language used, but also the factual context and the contract as a whole. And then if there's rival interpretations, it might consider which construction makes more business sense, but will also be alive to the fact that a party might agree something which, when looked at in hindsight, wasn't actually in his interest. So effectively, this highlights the importance of a carefully drafted clause with clear wording, as otherwise you're in the hands of the courts. And once you get there, what they find won't necessarily reflect parties' actual intentions or even the literal meaning of the clause. And I think it's also worth noting that that's how courts approach interpretation of contracts generally. And there's a view that actually when it comes to limitation clauses and exclusion clauses in particular, the court will be even more strict and stringent in the way that it actually looks to interpret them. In fact, there was a recent example, a case, Triple Point Technology versus PTT, where the Supreme Court basically noted that clear words will be needed before a court will take away a party's valuable rights and remedies. So it's kind of an important reminder. And I think the fundamental point, to go to your question, is to be as clear as you can.
Is there a, and it might not be easy without context, but is there an example of language which you could spot and you would know is ambiguous and you would be thinking, no, that's not going to work for us here? Is there a common trap that people fall into when they're ambiguous in their drafting in these circumstances?
Well, I guess there are a number of kind of examples that you see. I mean, I suppose the more general term that you use, the more ambiguous it might be. I think that might be why you might tend to try to use more specific wording if you can. And I think that perhaps another trap is that the more restrictive the clause, the higher the risk that a court might be to interpret it narrowly or find it to be unreasonable. I think, if you have example of a clause that effectively excludes all liability, a court's more likely to find that that's not what parties meant to agree, as it effectively wouldn't leave any remedies for breach. So I think it's generally seen as a better approach to accept some liability to a particular limit rather than try to exclude everything.
Yeah, absolutely right. I mean, you can see why it would be quite an unattractive proposition to think that somebody had genuinely gone into a contract and then decided that they would waive all liability for the person that they were contracting with. And to the extent that clauses look like they're doing that, those are the kind of ones that you're seeing the courts looking to kind of strike at.
Yeah, I mean, what I'm getting from you guys is very much this concept of you can have a clause that's actually too good to be true. It's almost too good for you, such that the courts are going to view it skeptically. So Ian, how do you avoid that trap that Ross has identified, that risk that the courts believe your limitation or exclusion is not reasonable?
Yeah, I mean, I think a lot of the reasons that Ross has identified are valid. I mean, I think some of the things go against what you might think, but I would say one of the things you want to do is you don't want to be looking to hide your limitation of liability provision. You want it to be clearly identified within the contract. It should be flagged in discussions that this is something that's happening. So a kind of separate clause, not buried or lost or hidden at the back of separate T's and C's. The moment that it looks like this is something that's been snuck in, that's when you're running the risk of it looking like it's not been a properly negotiated clause. I would also say, do try and clearly identify the liabilities that are limited. So, if there's only certain liabilities that are limited and they're limited in different ways, try and be clear. However, in a typically lawyery type answer, I would also say that there is a risk with being too smart in the way that you set these things out. There has been a trend, as with all contract drafting in recent years, to have really long, really detailed lists of all the different things that are limited and all the different things that are excluded and how all of these operate. And the problem with that is that if the list is very long, the court is certainly going to say, well, that's it. So if there's something that may fall between the cracks, you're not going to be protected for that. So in some ways, that's back to the kind of point that Ross and I were making earlier on. If you're looking to limit liability, you may be better to just have a general look, our liability for any claims under this contract is capped at X, and just put an amount like that in. You can have an argument about claims and how these, but quite often simpler is the better, unless you're dealing with a contract that is dealing with a whole bunch of various different and kind of quite complex scenarios. In terms of the reasonableness point, though, because that's really the test that the court apply, the key or the way that the courts look at it is in relation to equality of bargaining power. So they'll be looking to see whether or not these clauses have genuinely been negotiated or whether they've been imposed. But generally speaking, if you have limited your liability or capped your liability to price paid or contract value, or linked it to whatever your available insurance cover is, then for solid, sound commercial reasons, there's quite a spate of case law that the courts have said, well, those sorts of caps, those sorts of limits are reasonable. That, you know, if you're looking to recover, a recovery that is just what the party has received under the contract is fair enough. And that's why I think in my pipes case that I mentioned earlier on, had the liability there been capped at, say, the couple of $100,000 that were paid for the pipes, that, in my view, would have been a reasonable cap to place, and I don't think that clause would have been struck at.
Great. Now, that point, Ross, that Ian was touching on towards the end there of simplicity and capping liability, I think a lot of people who are joining the session today will be interested in that. So when we see contracts that place a cap on liability, can you take us through, will the courts respect that type of cap being applied here? And if so, is there a sound rule of thumb that you know is going to work for you if you're capping liability to a value, for example?
Yeah, I think to an extent this will depend on the circumstances of the contract, and each case will kind of tend to turn on its own facts. But I think a lot of the points that Ian mentioned there will come into play in terms of the court deciding whether it's reasonable. But I think if you have a commercially negotiated agreement, which clearly sets out the level of liability that parties have agreed to, I think the courts are more likely to respect it. But I think sort of beyond being as clear as you can, I'm not sure that there's necessarily a general rule of thumb. Often the cap will be linked to things like, as Ian said, the sums paid under the contract or the value of the contract, a multiple of this, sums insured, that sort of thing. But again, you know, whether the court will respect it, I think they will just look at the contract as a whole, because I think it might be, you know, there's circumstances where maybe a higher cap or a lower cap's been agreed in exchange for the negotiation of other terms elsewhere in the contract. And I think the court will, I think it comes back to, I suppose, the more general interpretation point. If you use clear language, which is unambiguous, the court is more likely to respect it.
And it can lead to some quite stark. I mean, one of the areas where you will commonly see liability being capped is in relation to expert determination. So you'll quite often see an expert determination provision in a contract. Now, the sums that are being disputed in an expert determination can be hugely significant, but the expert determination process itself is a relatively short process. In an expert determination as to the fees paid to the expert. But what that means is that if that expert is negligent in preparing that report, and the financial consequence to the parties could run to several million or hundreds of millions in some cases, the only remedy you're going to have against the expert will be for the amount of the fees that that expert was actually paid to do that determination. And there's nothing wrong with that, because everybody's gone into that freely. That's also kind of generally the market standard in that particular area.
Great. So, Ross, something else I wanted to pick up on with you was this concept of ruling out or limiting indirect or consequential losses. So we often see that in contracts, that reference to limiting liability for indirect or consequential losses. Can you tell us a bit more about what that means? What are those losses, and how effective is that type of clause?
Well, I think probably not as effective as people might think or hope. I think the reality is that most losses that arise as a direct result, or most losses that arise are a direct result of a breach of contract. So to find an indirect or consequential loss, there aren't as many losses that fall into that category. It's a sort of category that tends to be interpreted quite narrowly. Direct losses are generally the sorts of losses that you'd expect a party to incur following a breach, whereas indirect losses are a bit further removed. They tend to mean sort of losses that don't naturally result from the breach, and often constrain to the area where, in fact, even if you didn't have a clause, they might be too remote or unforeseeable to have been recoverable anyway. So what it means, again, will depend on the particular contract and the context in which it operates. But I think the use of the term indirect or consequential loss is ambiguous in itself, and I think lends itself to an argument whereby you're going to have potentially have a court try to decide whether or not your particular loss falls within that. So it may well be that you want to have it as a general sweep up provision at the end of a list, and often you will see it. But if you're relying upon that, it's you know, maybe not the best, and probably not as effective as a lot of people hope that it will be.
Yeah, and if you've got, so I completely take the point that the clause, this isn't some magic clause that perhaps people are placing a lot of reliance on. That concept of whether the losses are within the four walls of the contract or within the minds of the parties, what is the court's approach there? If you didn't have this type of clause in place, can you give us a feel for where does the court draw the line in remoteness when you're looking at losses coming out of a contract?
Well, I mean, I think generally it will generally grant relief for losses that are, I suppose, foreseeable at the time it was entered into. I think when you're starting to look at, I mean, loss of profits, kind of loss of business, wasted expenditure, all that sort of thing, will tend to be what's kind of generally accepted as direct losses. When you're kind of looking at things that are too remote, it might be, you know, for example, sort of something's bought and was actually intended to be put to some completely different use from what anyone could possibly have foreseen, and the parties then tried to recover those losses, and a court might say, well, you know, that's unforeseeable, too remote, it's not a direct result of the contract. But again, I think that's probably something that would operate potentially as a matter of kind of general law, whether or not you have that indirect consequential loss wording in the contract.
Got it.
Yeah,
Really
one
helpful.
of the areas that you quite often see claimed that you have mixed success with is wasted management time, so kind of wasted time dealing with the consequences of breach. But the way that has to be presented is that the people who were dealing with the consequences of breach would otherwise have been off pursuing more profitable opportunities. So you can see that as you start building that case, it becomes an easier thing to start throwing stones at and chipping away at and kind of going, well, you know, come on. And so these are the ones where it's not to say that they're not impossible to claim, but actually once you start to kind of dig into them and forensically examine them, they're much more harder to make stick.
Great. So everyone, just to let you know, we are making good progress with the session. We'll keep it to time. We should be done by about 1:30 if you're watching this live. Just to remind you, I'm feverishly watching the Q&A tab and seeing some questions start to come in. So if you have a question and it's not being covered by what Ross and Ian are telling us on the session, please put your question in. I want to try and get as many of them as possible
Don't
before the end.
feel obliged. There's absolutely no pressure to do that. I mean, I'm perfectly content to just carry on speaking to what we're prepared for. So there's no need.
Well, I hear what you're saying, Ian. I'm also encouraging the audience to chip in with their questions. So come back to you, Ian, for something that we've obviously talked about in advance, which is that question of, are there some liabilities that it doesn't matter what clauses you have, there are just some liabilities you can't escape or can't limit?
Yeah, I mean, we've spoken really what Ross and I have been speaking about in relation to reasonableness is that it's a statutory requirement, the reasonableness that comes from the Unfair Contract Terms Act. So we've been speaking about equality of bargaining power, availability of insurance, these sorts of things. That reasonableness requirement is a statutory requirement that comes from that. So the statutory requirement is you can't limit your liability in a way that's unreasonable. But what goes beyond that is there are just certain things that you cannot limit your liability for. So you can't limit your liability for personal injury or death caused by negligence. And to the extent that you attempt to do that, the clause will be void and unenforceable. So there have been some cases where a clause, even elements of it that were actually valid because of the way the clause was drafted, the whole clause has been struck at because actually reading it as a whole, it illegally sought to limit that kind of liability. The area that often, and I mentioned it again in the opening example, you also can't limit your liability for fraud. So what you often find is that if you are dealing with a strong limitation of liability clause, and this features particularly in IT contract disputes, you will find parties looking to find fraud angles to introduce. And fraud can mean not fraud in the strictest sense as such. It can mean a degree of recklessness. It can mean a fraudulent misrepresentation. So kind of a party saying something that they knew was untrue in order to induce a party to enter into a contract. So that's why quite often you will see these kind of allegations be made. And that does gives me, I think I've got time just briefly to mention one of my favourite cases in an IT contract dispute is the case of Sky against EDS, which I think is it's reasonably old now. I think it's at least 10 years old. But that was a case where the limitation of liability clause was struck at because the claim was based on fraudulent misrepresentation. And it was all based on kind of IT sales guy, a guy called Joe Galloway, I think his name was, or Joe Galloway. And he had made various what were found to be fraudulent misrepresentations that induced the contract. So therefore, the liability was unlimited. But the highlight for me in that case was, in order to show that Mr. Galloway was unreliable, he had emphasised how well qualified he was, and he had obtained an MBM. And counsel, in cross-examining Mr. Galloway, made clear that he had obtained the same MBM online for his dog the night before by filling in a form on the internet. And that's still one of the best moments you can imagine being in court when that came out in cross-examination and everybody on Mr. Galloway's side just going, where do we go from here? But that meant that I think that there was an interim payment on damages in that case in the region of 200 million. So you're talking about the consequences of that and the ability to avoid the liability cap were massive.
So that's a really interesting point. The idea that if you're faced with a limitation of liability and you don't like that and you're not sure how to challenge it, if you can identify that fraud at the outset or entering into the contract, that's your way to get away from that.
Yeah.
Okay, great. That's a really helpful tip. Now, on helpful tips, we're coming towards the end of the structured part of the session before we freestyle with the audience questions. Can you both give me 2 top tips each? So I'm looking for 4 top tips, 2 each, of what you're saying to the audience when they're dealing with limitation of liability clauses. So Ross, do you have 2 top tips?
Yeah, well, I think first one would be think about the context and circumstance of the particular contract and be wary of blindly using existing general styles, as what works in one contract won't necessarily work in another. As I said, you can have caps that are negotiated as part of or in exchange for other clauses. Those clauses might not exist in the other contract. It's also worth being conscious of a cap that refers to a defined term that isn't necessarily appearing in the new contract or has a different meaning, and it's worth just keeping track on that through drafts of the same contract as well. Linked to this, I think, would be just to keep in mind how the clause interacts with other clauses in the contract. For example, does it accidentally reduce the effectiveness of a warranty or an indemnity? It's also worth checking that the other parties complied with the likes of notice provisions, time limits, termination provisions, or even engaged in a dispute resolution procedure if the contract provides for one. Because if they've not complied with the contractual requirements, it may be that actually they're limited or excluded from going ahead with the claim anyway without even needing to rely on the limitation clause. So it is worth just kind of keeping in mind what else is in there that might be helpful if you're looking to rely upon that.
Great. Ian, some top tips, 1 or 2?
Just one, probably. I would just say, just remember that we've been talking about limitation clauses, but it's not just limitation clauses that can limit liability. We've been speaking about fraudulent misrepresentation. There are other key clauses that can feature in a contract that can be quite significant in limiting liability. For example, an entire agreement clause that makes clear that effectively you only look within the 4 walls of that agreement. That can be significant in terms of limiting liability only to claims that fall within the 4 walls of the agreement. And I would just emphasize the point that Ross made, that even if you have a limitation of liability provision, that doesn't mean that we talk about unlimited liability, but there are still common law limitations on liability that will mean it's not just whatever number the party claimant comes up with. So I would say, in summary, consider limitation provisions and make sure that those limitations are flagged. But having a limitation provision in your contract can make a massive difference to potential exposure in the event that the contractual relationship breaks down.
Great. Thank you both. Right, so we've got a bunch of questions. I'm going to try and get through a couple of these at least. The first, you've mentioned equality of bargaining power. Are you better not negotiating the value on a limitation clause so you can then run a reasonableness argument before the courts? So does that make sense to you guys?
It does, and I would say definitely not. In fact, quite the opposite. Sitting back and not challenging the clause is completely the wrong thing to do. If you challenge the clause, there's a decent chance that you might actually achieve by negotiation a limitation that both parties can live with. But actually the test, when we're talking about equality of bargaining power, the stronger argument, if you're going to go down that road, is to show that you attempted to negotiate the clause and the other party said, no, this is not something that we negotiate. So you would have to be able to evidence at least an attempt to negotiate in order to say that it wasn't something. So sitting on your hands and going, oh, that looks like something that's a bit punchy, but then not making any attempt to resolve it or address it is very much the wrong approach to take.
Got it. Okay, and I think the next question it's almost the same, well, it's not the same question, but it raises similar issues. Given the risks, why would anyone ever accept unlimited liability in a contract? Ross, do you want to start on that one?
I mean, I suppose usually they wouldn't, but I guess it kind of goes back to what we said about and what Ian said there about the common law restrictions on liability anyway. It might be that for whatever reason the party's comfortable with the risk and is kind of reviewed and is aware of what could potentially arise that would be recoverable, and is happy to take that, particularly if they've sort of potentially in exchange for that negotiated some other favourable term elsewhere in the contract.
I think the other thing I'd say is there are certain industries where it's just not tolerated, and it seems particularly harsh, but actually there are certain industries where if you want to play in that park, if you're the one who's limiting your liability, you're simply not going to get any business. I mean, even and lawyers you would think would be great at limiting their liability all the time, but even amongst law firms, there are areas where a particular limitation of liability is not tolerated, or it has to be reviewed or negotiated. So there is always going to be a business decision, and that's why I would say it's worth at least attempting to negotiate these clauses, because you then have to take a view: is this piece of work worth it in order to address the potential exposure? I think probably the harder thing to assess is, well, what's the potential exposure here? Because if you've not limited your liability on something like again, back to the pipes example, but something goes wrong that you've not really anticipated, you could be looking at really quite a big number, and you don't have a huge amount of protection against that.
Great. Now I've got two questions which are similar issues raised. I'm going to clumsily try and group them together, but you guys can maybe peel them into two separate questions if need be. One is the limit of liability to the value of the contract unreasonable? And the second is, how would you recommend calculating an appropriate cap? So I've thrown two things together there, which hopefully you can break down.
Do you want me to go first, Ross, and then you can chip in?
Sure.
So I think I mean that the best examples from the cases about what are reasonable, and that the general kind of rule of thumb is contract price. So if you limit your liability, then in most of the cases will say, and the cases do say, if you limit your liability to the amount that you are actually receiving under the contract, that will be reasonable. But that does not mean that you have to go that high. You can actually come down a bit from that if it's justified in the circumstances. So that's not by any means, that's a rule of thumb as something that is generally viewed as reasonable. And the other element is limiting your liability to the amount that you are insured for, or to the amount that insurance is available in the market for, is generally viewed as a reasonable limit on liability. So that would be the starting point for any kind of consideration or discussion about it. And I think once you start to move from those, you're straying into territory where there could be a degree of challenge, and people will look at equality of bargaining power and that sort of thing. I don't know. Did I get that right, Ross? Is there anything you need to edit?
Yeah, no, I think that's right. And I suppose it's just also being conscious of again, going back to the clear language, being clear exactly if you are going for contract price or sums paid or whatever, if there are sort of a number of different aspects of the contract, if you want to ensure that that's kind of an aggregate of the sums paid and not individual claims, it's worth noting that. I think if anyone saw, there was a case recently in England where there was a real issue there where there was reference to a cap, and it referred to the total liability arising, and then in relation to the calculation, there was reference to the claim, and the other party had tried to argue that this meant each claim in relation to, and it was an IT contract, so it was in relation to each different sort of statement of works under the master service agreement, and ultimately the court found that it didn't include that, because if it had meant to say each claim, it should have said that, but it's again just that was sort of a flag that it's worth being very clear if you are going for contract price, and that is going to be reasonable. You also want to make sure that you're kind of making it clear where the sort of limit of that cap is.
Great, thank you, Ross. We've reached the end of our time. Perfect timing, almost. We're about a minute over, so that's nearly perfect for us. Takeaways from the session: when it comes to managing risk, limitation and exclusion clauses are worth their weight in gold. As Ross has just noted there, the devil is in the detail. Only a carefully drafted clause will give you the protection you're seeking. We can see that getting it right will provide certainty and give you confidence in your dealings. On the other hand, get it wrong, and the best laid plans can be turned on their head. As Rabbie Burns never said, I don't think he ever said that. My thanks to Ian and Ross for their wise words today. Thanks to all of you for joining us. If you have any questions in connection with today's session, please do get in touch. There was a couple of questions I didn't get to. We'll reply. And please to join us for our next risk session, which is on the 5th of December and is on cyber risk. So until next time, thanks for joining us and goodbye.